to this IP Manthan event. It's the first time that we've had online contact with the Office of the Controller General of Patents, Designs and Trademarks. And we're absolutely delighted to have this contact. And we're very interested to learn about the Indian trademark and design system from Mr. Punya and from Mr. Bhattacharya. From our side, just briefly introduce my colleagues, Mrs. Koyas, chairperson of the 4th Board of Appeal, and Mrs. Budovichkova from the Board of Appeal President's Cabinet, and myself will be presenting. We hope you find our presentations interesting, and if you do, I would also just let you know that we have an IP case law conference at the end of this month on the 29th and 30th, which is a hybrid event and which is indicated in our slides. So if that's of interest to you, please feel welcome to join us then. Thank you very much.
Thank you, sir. I also welcome Ms. Neena Horjus, the chairperson of the 4th Board of Appeal. Ms. Neena Horjus is the chairperson of the 4th Board of Appeal of the EUIPO since January 2022. Earlier, she was the judge for over 10 years and also the head of department for 1.5 years at the Finnish market. She has worked at the European Law Unit of the Finnish Ministry of Justice for 4 years and has published several articles relating to trademarks and competition. Ms. Neena, I welcome you to IPM. I also have Ms. Janka Budovikova, the project manager of Boards of Appeal. Since September 2018, Ms. Janka has held the position of EUIPO Boards of Appeal project manager for Boards of Appeals cooperation activities with external stakeholders focused on trademark and design effective dispute resolution. In 2013, she joined the EUIPO cooperation team as a seconded national expert. She was working at the comprehensive program until 2018. Ms. Janka, I welcome you to the IPM. We also have with us Ms. Alexandra Kostovic, the head of the cabinets of Board of Appeal. Ma'am, thank you so much for joining. Now from the Indian Intellectual Property Office, I welcome Mr. Sanjay Bhattacharya, who is the Joint Controller of Patents and Designs. He is currently heading the Designs Wings in IPO Kolkata and has a rich experience of working in both patents and design sector with an experience of more than 20 years in this sector. Prior to joining IPO, he has worked in service sector, including PSU companies of India. Mr. Sanjay Bhattacharya, I welcome you to the IPO. Mr. Vikas Puri, he is the head of office, Trademark Registry Delhi, which is the biggest registry all over India. His efforts in managing the TMR Delhi were instrumental in reducing the backlog in show cost related matters. He has a very strong background in law and administration. As before joining this office, he served as the Assistant Public Prosecutor in the Central Bureau of India. Mr. Punya, welcome to ITM. And finally with us, we have Professor Dr. Unnati Pandit, the Controller General of Patents, Designs and Trademarks, Register of Copyrights and Geographical Indication. So to begin with the introductory part of IP Manthan, I request you to kindly proceed again. Thank you so much.
Thank you, Himadri. Indeed, I welcome Mr. Gordon Humphrey and the European Union Intellectual Property Office team for the wonderful and insightful IP Manthan. This IP Manthan is designed as such to invite the brainstorming on the developing topics on intellectual property and to look way forward what is going to happen in the field of intellectual property rights and how in India and outside India the kind of a development which is happening. So this is the platform which we have created post-COVID to productively utilize the foresight which we all have developed to stay connected via virtual mode. And also offer one of the best platform for the knowledge sharing on different topics. So friends who have recently joined this particular session, I would like to mention that today's IP Manthan, the IP Office India is planning with the European Union Intellectual Property Office. And this is one of such important topic which we are going to discuss as the appeal system, specifically in trademarks and design in India and European Union Intellectual Property Office. This is most important for all of us to learn, even if we are having the questions, queries, concerns, grievances, but how this can amicably be resolved by utilizing the effective tools which we have in the court of law. And before that, how you can utilize the available remedies, which looks like a low hanging remedial action to be taken up within the IP administrative system. And that's why today from IP office, Vikas Punya is going to discuss about the appeal framework and the remedial measures which Indian IP office has taken up in trademark. And equally Mr. Sanjay Bhattacharya, who is also head of office in design wing of the IP India, is going to discuss about the various provisions under which the appeal and review mechanism can be enabled. And similarly, the team from the European Union Intellectual Property Office under the leadership of Mr. Gordon Humphrey is going to have a similar discussion. I am sure we all are going to utilize the knowledge which is going to be shared on this virtual platform and will utilize this effectively to reduce the grievances and also address the concerns which are there in the system. We cannot say that the IP system or IP administration is 100% foolproof. Otherwise, no office will require any kind of a grievance or appeal system. It's a part of the I can say that it's a vibrancy of the IP system to establish such a mechanism under which there is a seamless communication happening between the office and the stakeholder, and amicably all the concerns are getting addressed. And it is a wise call for each one of us to learn this system mutually between the European Union IP office and the Intellectual Property Office in India. This is one such initiative which we have triggered to have such discussion dialogues on the international forum, and especially first time with the European Union IP office. And in future also, I'm quite confident that we will create such framework with the European Union and mutually extend the benefit to the stakeholders from both the sides. India being the third largest trademark ecosystem in the world, as notified by the World Intellectual Property Organization, and the design system with over 80% growth, which is again as noticed by the World Intellectual Property Organization in the annual report, and the kind of a vibrancy which IP ecosystem has gained in a post-COVID era, it is important for the European Union stakeholders to learn more about the Indian IP ecosystem, and vice versa. The Indian stakeholders also require to learn more about the European Union IP office and the various provisions which they are enabling under ease of doing business from both the side. So I once again welcome the European Union IP Office team and the Indian IP Office team for a wonderful and insightful IP Manthan on appeal system in trademarks and design in India and European Union IP Office. Over to you, Himadri, for the further proceeding in this matter.
Thank you, sir. I now request Mr. Vikas Pania, the Head of Office, Trademark Registry, Delhi, to kindly proceed with an overview of trademarks and designs appeal regime in India. Thank you.
Thank you, Himadri. First of all, very good afternoon to all of the participants here. I'm very grateful to the Honorable CG sir to provide this opportunity to discuss the appeal mechanism under trademark law on this platform. First of all, let me share the PPT and the points which we are going to discuss in this presentation.
Yeah, you can share. The share is enabled.
Himadri, can you please put the PPT? I think the share is not.
You have, I think, Himadri, can you share the PPT? Some connectivity issue looks like.
Yeah, sure. I'll share.
Yeah.
Himadri, can you go to the next slide? We will be discussing 5 points here. First, we will see that before the 1919 Act, what was the procedure there in the earlier 1958 Act, the Trademarks Act, which was abolished or repealed in 1999. Then we will discuss about the provision under the 1999 Act and the creation of the Intellectual Property Appellate Board and the appeal mechanism under that board. Thereafter, the Tribunal Reforms Act came into force and the IPAB got abolished, and the appeal system under the Trademarks Act now is with the various high courts of the various states. So for Delhi jurisdiction, the Delhi High Court has the IPD bench. Subsequent to that, Madras High Court has also established an IPD bench, IPD division rather. IPR benches in various high courts such as Kolkata High Court, Mumbai High Court, and Madras High Court also. So we will first see the provision that was there in the 1950 Act. Himadri, can you please go on to the next slide? Yes. So under the 1950 Act, Section 109 provides for the appeal mechanism. So that appeal could have been filed against any order decision of the registrar of the trademark to the High Court. And the appeal could only be filed by an aggrieved person. So aggrieved person means the person who has faced an injury in terms of, let's say, if an show cause hearing was there before the registrar, and the refusal order was passed by the registrar or on behalf of the registrar by any officer who has the power under Section 3 of the Trademarks Act. So against that order, the person could have challenged that order and go in appeal to the High Court. That could be the appeal mechanism could be used when there is a favorable order also. But let's say a person was asking for an application in a class that he used so and so goods under so and so class in the entire jurisdiction of India. But let's say the registrar has limited the scope to one state. Let's say I apply for an application for the all India jurisdiction, and the registrar has limited my jurisdiction to the state of UP. So I could also have challenged that order before the High Court. And in the earlier Act, in 1950 Act, there was a provision with the High Court also, that if a High Court judge wants to refer a matter to a bigger bench, so he could do so. Like if he says the matter is of so much of importance that division bench should hear that matter, then he could have forwarded that matter to the division bench. So that was the provision. That was the procedure in the 1958 Act. So that 1958 Act got repealed or got abolished via the 1999 Act. Himadri, can you please go on to the next slide? So in 1999, in the era of globalization, when the commerce, brand names, trade names have become extremely valuable, there was a necessity that the minimum standards of protection and effective enforcement mechanism as per the TRIPS agreement, which India also follows, and that led to the repeal of 1958 Act, and it subsequently 1999 Act of Trademark was enacted, which inter alia specify major. There are very large changes have been made through that act, which also provides for an establishment of an intellectual property appellate board for speedy disposal of appeals from registrars, orders, and decision. So after the 1919 Act, there was one more layer added to the appeal mechanism. So prior to that, once an application was refused by the registrar of trademark, the appeal used to went to the High Court. But after 1999, and IPAB started working in 2003. From 2003 to 2021. So in between these 17-18 years, there are these three layers of appeal mechanism. First, a matter was decided at the end of the registrar of trademark, and decision from that could go in appeal to the IPAB. And from there on, if anybody has to challenge the IPAB order, he will need to go to the High Court. So after 1999 Act, IPAB used to hear the appeals from the trademarks as well as copyrights, patents, all the intellectual property matters went to the IPAB, which was a administrative quasi-judicial form. And in 2021, when the government decided and rationalizes the Tribunal Reform Act, many other tribunals were also got abolished. IPAB was one of them, and the reason was that, there used to be lack of staffing. There used to be other concerns also, which ultimately resulted into abolishment of the IPAB. Himani, can you move to the next slide, please? So the establishment of the IPAB came into force on 15th of September 2003. It was a very closed body with a chairman and a vice chairman, along with the technical members and the judicial members also. But in a way, it was a concentration of powers, rather, that that the chairperson was used to be the ultimate deciding authority in many ways, because once a matter got listed before one member, it will stay with that member till the disposal of the appeal. Yamani, can we move to the next slide? So the IPAB had jurisdiction to hear appeals and disputes arising from decision of the registrar of trademark under the relevant intellectual property laws. IPAB exercised appellate jurisdiction over orders, decision, and directions issued by the registrar of trademark under the Trademarks Act 1999. The rectification petitions under section 57, and then in now in appeal section also, that used to be filed before the IPAB only against the registrar's order. So after the abolishment of the IPAB, now at present under the Indian Trademarks Acts, lots of section under the appeal head from section 84 to 100 got repealed, and at present we have section 91, which says appeals to the High Court, which is almost the same as per the earlier act only. It just changes the jurisdiction for appeal filing from IPAB to the Delhi High Court. And the time period of filing of appeal is 3 months from the date of the communication of the order to the interested party or to the applicant. So within these 3 months, the party can file an appeal, and if there is any kind of delay, the High Court can condone it, and the condonation will be done under the General Limitation Act 1963, in which the party needs to show the sufficient cause for the delay, and the High Court then can condone the delay. Next slide, please. So this is basically the section 91, which I have already discussed. So after the expiry of stipulated period can be admitted if sufficient cause is shown. So that is on that burden of proof is on the applicant to show the sufficient cause. Next slide, Yaman. Yaman, can you please move on to the next slide? So the Tribunal Reforms Act, which was earlier was in an ordinance form, which was subsequently become an act and abolished various appellate tribunals to streamline their functioning and reduce the number of tribunals. This consolidation helps in optimizing resources and increasing efficiency. So with trademark acts, this has done one additional thing also. Now earlier we used to have 3 layers of appeal mechanism. At present, it is only 2 layers of appeal mechanism, which is in line with the international standards and practices which are adopted by many other countries also. So now we have an appeal in the High Court, and if any party feels aggrieved by the High Court order, they can go in the division bench of the same High Court. Okay, next slide. Next, this we have mentioned section 91 of the Trademark Act. So the Tribunal Reforms Act, after the Tribunal Reforms Act, once the appeal mechanism is went to High Court, the transfer of all the pending matters with the IPAB is transferred to the IPD bench of the High Court. Subsequent to the Reforms Act, the Delhi High Court, the then Chief Justice has formed a committee comprising of Honorable Justice Ms. Pratibha M. Singh and Honorable Mr. Justice Sanjeev Narula. The committee subsequently submitted its report, and based on the recommendation of the committee's report, the then Honorable Chief Justice directed to create an intellectual property division in the High Court to deal with all the matters related to intellectual property. And subsequent to the creation of the IPD division, the rules were framed, which is very detailed rules with regard to appeal system of all the IPR subject related matters. The rules consist, there are 40 rules and 2 schedules to it. Schedule 1 is about the forms and schedule 2 is about the fees. So this IPD, which is created beside dealing with original proceedings like rectification proceedings which are now directly filed before the Honorable Delhi High Court with respect to Delhi matters, and in other jurisdictions, the other high courts have the jurisdiction. So this IPD would also deal with the writ petitions, regular first appeals, and first appeal filed against orders, which are these RFA and FAOs are from the appeals from the district courts, which the High Court will hear. The High Court under IPD consists only of single judges. Single judges benches are there, and if the matter pertains to the commercial matters under Section 3 of Commercial Courts Act 2013, those matters which will go to the division bench of the High Court. But apart from that, all the IPR matters will come before the IPD divisions. So this being is a significant step. The creation of the IPD is in line with the global practices which have been followed. And there's one more thing I want to mention here is that after the creation of the IPD, there is a Parliament Standing Committee which at one point of time thinking to reintroduce the IPAB against. But after seeing the jurisprudence which have evolved in the IPD division in the High Court, they have recommended that the IPD division of the Delhi High Court is working great, and on line of the same, the other high courts also should establish more and more IPD divisions. So subsequent to which the Chennai High Court has established an IPD, and various other high courts have the IPR benches as of now. So the Delhi High Court has come up with very detailed rules in this regard, which are the Intellectual Property Right Division Rules 2022. So which has very elaborate. The appeal under the TM Act is filed as per the provisions of Rule 2 Clause D, which includes an appeal filed before or transferred to the IPD under the following sections of the respective acts. So these acts contains Trademark Act, Copyright Act, Patents Act, the Geographical Indications Act, and all other intellectual property related matters. There is one more thing mentioned in these rules also, that the patent agents and trademark agents can also appear before the IPD division. They have a right to appear in the audience, as well as they have the right to appear before the IPD bench, but that is along with the legal practitioners. Further, the IPD can take help of the experts also. They can appoint the experts related to the subject matter which is before the High Court to decide, and there is one very important thing which is there in the rules, is rule 19, confidentiality clubs and redaction of confidential information. So the experts which have been appointed in any matter, the High Court can ask them to be in a club and sign a document that they are not to disclose any confidential information, be it trade secrets or any other information which the party doesn't want to disclose. Himani, can we go to the next slide, please? So these we have just discussed, that the jurisdiction of IPD in trademark cases is every IPR subject matter or case or proceedings or dispute filed before or transferred to the IPD as defined in Rule 2 Clause I, 2 Clause J and 2 Clause L shall be heard and adjudicated by a single judge of the IPD, except those that are to be decided by a division bench as per Section 13 of the Commercial Courts Act 2015. The procedure for filing appeals, including fees, form, nomenclatures to be used before the IPD, is comprehensively provided in Delhi High Court IPD Rules 2022. Rule 6 particularly deals with appeal procedure before IPD. And the substantive provisions, of course, will be dealt by the substantive act, like the Trademark Act in this case. So this is the case which I want to discuss with respect to the jurisdiction of the IPD. This was a recent case in the Delhi High Court, IU United Care Limited versus Union of India. So in that case, what happened was that one rectification petition was filed before IPAB. That was filed in 2013. So IPAB decided against allowed the rectification, and the IU United Care LLP filed the petition before the Delhi High Court. So the case of the petitioner is that as the IPAB is now abolished and the rectification was allowed against the petitioner, now the petitioner wanted that the case should be listed before a division bench, not before the single bench of the IPD. So that was the issue in question before the Delhi High Court. So deciding in that case, the Delhi High Court said that the single judge of the Delhi High Court has not replaced the IPAB. This is not the case. The High Court had said that the IPD is having the judicial superiority over the IPAB, also the administrative superiority also. So that's what they have said. So they said that even if the IPAB has decided this, it will still go to the single bench of the IPD, before the single judge of the IPD bench. And that is very well in line with the IPD rules also. So in that case, they have highlighted the rule 4 with respect to the jurisdiction of the IPD, which says every IPR subject matter or case or proceeding or dispute filed before or transferred. In that case, it has been transferred to the IPAB because before the IPD, as the IPAB is abolished. And this is defined in Rule 2 Clause I, 2 Clause J and 2 Clause L. And that is to be heard and adjudicated by a single judge of the IPD, except the cases which fall under Section 13 of the Commercial Courts Act. So in that case, the court said that it is not the case that in every case which has been heard by the IPAB, first the single judge, if it is heard at the IPAB stage, it will go to the division bench. The single judge has the jurisdiction and has the power to decide the matter. Next slide. So the decision in this case was that the court effectively repudiated the argument that there existed any parity between the jurisdiction exercised by IPAB and a single judge bench. It noted that a single judge bench of a high court is hierarchically or at least judicially superior authority to IPAB. The court elaborated on this reasoning by explaining that while hearing and deciding a challenge to an order passed by the IPAB, the court is exercising supervisory jurisdiction as well as the jurisdiction of judicial review over the decision of the Intellectual Property Appellate Board, and while deciding upon an original rectification petition, the court is exercising its original jurisdiction vested in it by statute. Though in this case there is a slight anomaly, because now what happened is that every new rectification petition will be filed before the single judge of the High Court, and if it is challenged, it will go into the division bench. But if the same rectification petition was decided by IPAB before its abolishment, the same will come in appeal before a single judge of the High Court. So that is the slight anomaly in this in this decision, and that is because even in 1950 Act, even in 1999 Act, there is no clear-cut provision in the Trademark Act that that once the matter is before IPAB or the High Court, where the second appeal will lie. Though the IPD rules covers it, that the second appeal will lie in division bench, but the existing Trademark Act is silent on this. So this is the appeal mechanism as of now in Trademark Acts. I just quickly want to share some more information with respect to the intellectual property division, which is currently working under the Delhi High Court. Is that that information is of 2023, because in 2023 the IPD has completed its first year. It was formed in 2022. Is that over 1,000 cases were filed in the IP division's first year. Then 750 plus IPR disputes cases have been finally decided. Out of these total cases, over 100 patent appeals have been filed, and more than 50% of the trademark appeals filed before the IPD have been disposed of. Currently, there are around 4,000 IPR matters that have been pending before the IPD. But going by the Parliamentary Committee's recommendation that the IPD and the appeal system is enhancing the IPR jurisprudence in India with diverse viewpoints, because the IPR matters are getting listed before many judges through the roster system. So eventually it will improve our quality in terms of order writing, in terms of decisions. So though it is still in a very nascent stage, but over the course of years, the future is very bright for the IPR jurisprudence as far as the IPR community in India. Thank you all very much for listening to me patiently. Thank you, Nihmani. Over to you.
Thank you, sir, for a wonderful presentation on trademarks act in India. Moving ahead, I request Mr. Sanjay Bhattacharya, the head of office, Design Wings Kolkata, to please present us an overview of the designs of the regime in India. Thank you. You can please proceed ahead.
Good afternoon to all. And my topic is provision of appeal under the Design Act 2000. Actually, Design Office function under the superintendence and direction of Honorable Comptroller General, and discharges its statutory function as per the provisions of Design Act 2000 and corresponding design rules of 2001. And under the delegation power, in our design examination, it is a two-tier system, and under the delegated power, controllers are acting in handling the design applications, and examiners first examine the design applications filed before the design registry as per the provisions of Design Act and Design Rules 2001, and forward the report to the controller, and then controller take further action on it. And examiners are also assist in the procedural and administrative and other issues of design office, and final authority is the controller. All controllers, they are working under the delegation of power from Honorable CGPDTM, and they ultimately register the design or take final decision on the design application filed before design registry. Either it can be registered or it can be refused. Next. Now, when the application is either registered or refused, it is appealable. A controller decision is always appealable. So, as per the provision of Design Act 2000, any appeal from the decision of the controller of designs shall lie to the High Court. So, it can be challenged in the High Court. So, appeal can be filed under the provision of different sections like Section 5, Section 35, and Section 19(2) of the Design Act 2000. And Section 36 describes the amount of time period for appeal and other provisions. Now, in section 5.4, the controller, if he thinks fit, may refuse to register any design file before design registry. And any person aggrieved by any decision of design registry can go to the High Court against such refusal. And then appeal under section 35. Now, controller may refuse any application to register a design of which the use would, in the opinion of the controller, be contrary to public order and morality. In this case also, an appeal can be filed by the aggrieved party to High Court and against the decision given by the controller. An appeal under section 19.2. Now, in case of registered design, there is a provision of cancellation. Now, as per the provision of section 19 of the Design Act 2000, any person interested may present a petition for the cancellation of the registration of a design at any time after the registration of the design. Normally, if once design application is registered, the tenure of registration is 10 years from the date of filing or date of priority. Now, any time in between the 10 years, one can file a petition for cancellation of that registration design, and there is a particular form for that, Form 6. And the petitions for cancellation of registered designs are proceeded and decided under the provision of Rule 29 of the design rules. Now, in section 19.2, an appeal shall lie from any order of the controller under this section to the High Court, and the controller may at any time refer any such petition to the High Court, and High Court shall decide any petition so referred. Now, in case of cancellation petition, it is decided by the controller, and after it is decided, that decision, if any party is aggrieved, they can go to High Court. And otherwise, Sumoto controller also having the power to refer particular any cancellation petition to High Court. But normally it is always usually as per practice it is decided by the controller, and after that, if applicant or registered proprietor or the petitioner is not happy, they can challenge the decision to High Court. Appeals to High Court, where that is the regarding timeline, where an appeal is declared by this Act to lie from controller to the High Court, appeal shall be made within 3 months of the date of the order passed by the controller. Now, once it is decided by this design registry, within 3 months, it has appeal should be filed to the High Court. And in calculating the said period of 3 months, the time, if any, occupied in the granting a copy of the order of appeal against the shall be excluded. Now, if there is a time gap between issuance of order of that particular design application, then that time should not be counted within the period of 3 months. The High Court may, if it thinks fit, obtain the assistance of an expert in deciding such appeals, and the decision of the High Court shall be final. Now, if any petition is filed before the High Court challenging that decision of design registry, then High Court, in order to decide that appeal, they can take help from expert, and the decision given by the High Court is final. High Court may make rules consistent with this Act as to conduct and procedure of all proceedings under this Act before it. So High Court is also having the power to just make rules in order to adjudicate the matter or like that. And all the decision given by the High Court, it is obviously appealable against in the Supreme Court of India. So any decision given by the order given by the High Court may be challenged before Supreme Court, and they are the final authority in India. That's all. Thank you.
Thank you so much, sir. Moving ahead, I now move towards the European Union Intellectual Property Office. Firstly, I would request Mr. Gordon Humphreys, the President of Board of Appeal ad interim, to provide us with an overview of the trademark and design appeal regime in the European Union. Thank you so much.
Okay, sorry, for some reason I had the video on, but now it won't let me restart it. Well, let's not waste time. Apologies for that. Yes, I would just like to try and deal with some of the points that were raised by in the two very interesting presentations that were just given, and try and make some parallels between the two systems, that sort of compare and contrast. So anyway, just let's start with a little bit of background to give you an idea of the sort of volume that we have at the European Union Intellectual Property Office. So you can see, based on last year's figures, that we received both EU trademarks and registered community designs. That's an EU design. We received about 270, a bit over 270,000 applications. Next slide, please. Could I have the next slide, please? Yeah. So, who's our biggest filer? Well, both in trademarks and designs, although we're issuing an European Union trademark and a European Union design, in fact, in both cases, China is the biggest applicant and the biggest user of both the design and the trademark systems in the EU. In fact, China accounts for about 14% of all EU trademark applications, and 40%, that's 40%, of all design applications. And in both cases, that's followed by Germany, and then for trademarks, the United States of America is in third place, and it's Italy for designs, with the USA going down to fourth place. Now, surprisingly, given the size of and importance of India, there are relatively few trademark applications from India, and even fewer design applications from India. I'm not quite sure for the reasons for this. Perhaps you incorporate companies in Europe and therefore the applicant appears as a European company. I'm not quite sure. But anyway, these are the figures that we have. Could I have the next slide, please? Now, to give you an idea of the judicial system and how our boards of appeal fit into all of this, you see that we have at the EUIPO what we call a first instance, where we make absolute grounds examination, and we also have relative grounds proceedings in cancellation matters, opposition, and invalidity concerning designs. Right. So the cancellation and opposition concern trademarks, and invalidity concern designs. This is more or less equivalent to what you have as a registrar at registrar level in India. Then appeals can be made of the decisions of that first instance to the boards of appeal where I and my colleagues work. Now, that is equivalent to what you used to have in India of your intellectual property appellate board. The peculiarity of well, we'll go into a bit more detail about what the boards of appeal do. Just know for the moment that we have these boards, and we also have a grand board, which is effectively an enlarged board, which is also part of the boards of appeal. Now, decisions of the boards of appeal, including the grand board, can be further appealed to the general court, which is a bit like the high court system that you have in India. Now, in reality, the three levels that I've just described are the ones through which most cases, or at least most cases, go no further than the general court. And in fact, 90% of cases stop at the level of the boards of appeal. Only about, in fact, it's 11% are further appealed to the general court. However, theoretically, there is a further right of appeal to the Court of Justice of the European Union, but the grounds for such appeal are very limited and are rarely, if ever, successfully invoked. So the Court of Justice is a bit like your Supreme Court. Okay, so yeah, we can move on, please. So we're an internal body of so the boards of appeal are an internal body of the European Union Intellectual Property Office. However, we are independent and we operate like a court, effectively. So we are quasi-judicial. We are the second instance of the EUIPO, so the examiners are the ones that make the first decisions, and then their decisions are appealed to us. We review those first instance decisions if and when they're appealed. And the idea is that we act as a filter to the general court and the Court of Justice, so that the general court doesn't become overburdened with cases. And the decisions that we take guide the practice of the first instance of the office. Our decisions are only binding on the first instance of the office if they come from our grand board, our enlarged board. However, in reality, they heavily influence the practice and often guide it being incorporated into the guidelines of the office. Next slide, please. Okay, so just to give you an idea of the structure of the boards of appeal, you can see on the right-hand side that we are divided into 5 boards of appeal. All boards of appeal deal with trademark matters, apart from the 3rd board of appeal, which deals exclusively with design rights and not with trademarks. And you can see that all decisions or all cases that come before the 5 boards of appeal, it's possible for there to be a referral to the grand board from any of those boards of appeal. And decisions can be taken by the grand board. I'll explain that in a little while. You'll see on the left-hand side, sorry, no, if we could go back. On the left-hand side of this slide, that we have litigation service. This means that if any of our decisions of the boards are challenged before the general court, and you'll remember that I just said that about 11% of our cases are actually challenged before the general court. The litigation service, which is part of the boards of appeal, defends our decisions before the general court. However, the litigation service has different staff to the individual boards of appeal. So the people taking the decisions are not involved in defending them before the court, the general court. Okay, if we could, next slide, please. Yeah, this is just summarizing a bit what are the kind of decisions that are being appealed. And here I should just say that I noticed that in India, you talk about an aggrieved person. We talk about a party that has been adverse or who has been adversely affected by a decision. So where a person is adversely affected by an examination decision on absolute grounds in the case of trademarks, and in designs, you may already know that the designs are they have very little examination in the European Union. We only examine on the basis of public policy and morality, like you do in India, if I understood correctly. And the second matter that we examine is whether the design complies with the definition of a design, that it's an outward appearance, that it includes of a product, and that it's composed of lines, contours, and various other things. The next, we also examine at first instance opposition proceedings. So these are proceedings between two parties. I'm not sure what the situation is in India. In many IP offices around the world, there are there's an ex officio examination of relative grounds. At the EUIPO, and so at the European level, that is not the case. Opposition against a trademark application has to be made and lodged by a party who has an earlier right. And then the other possibility is proceedings for cancellation of trademark, or again, parallel to that, registration or invalidity of community designs and any register matters such as disputed transfers of trademarks, licenses, and so forth. What's our board composed of? Well, we generally take decisions as a panel of 3. So unlike your high court that takes decisions as an individual judge, we take them as a panel of 3. There are very limited circumstances in which we can take a decision as a single member, but really they're not important for our present purposes. And in other cases that go to the Grand Board, our enlarged board, it's actually a 9-member panel. I'll come on to that later. Our members are appointed for renewable periods of 5 years, and we can only be removed from office by the Court of Justice, which, as you remember, is our Supreme Court, for serious grounds only. And I have to say that has never occurred in the history of the EUIPO. Could we have next slide, please? How many appeals are filed in a year? Well, you can see that last year we received just over 2,500 appeals. The majority of them concern inter partes cases, so adversarial proceedings between parties disputing either the registration of a trademark or a trademark that's already been registered, or a design that has been registered. Next slide, please. In terms of appellants, so parties appealing before the boards of appeal, you will see interesting that China doesn't feature on that list. In reality, the Chinese, if they have a problem with a trademark, they simply abandon that trademark application and they refile, either using a different trademark name or the same trademark that they try to get through a second time. You will also see that India is not a big user of our appeal system at the moment. You're in 36th position, but that probably reflects the fact that there are not a lot of trademark or design applications coming from India at the moment. Could I have the next slide, please? In terms of our office operates primarily in 5 languages, so Italian, French, Spanish, German, and English. However, English is by far and away the most important language that's used in proceedings. Have the next slide, please. How many decisions do we actually issue in a year? Well, last year we issued over 2,600 decisions, which was 5% more than the previous year. And again, most of our decisions are on inter partes matters, so adversarial proceedings, which means by definition they tend to be more complicated than the ex parte absolute grounds cases that simply involve examining whether a trademark is descriptive or lacks distinctive character in most cases. Next slide, please. So what's this grand board that I've been talking about? I said that it has a composition of 9 people. The president of the Board of Appeal, the Boards of Appeal has to sit as the chair of that grand board, plus 4 chairpersons from the individual boards and 4 rotating ordinary members, so 9 in total. As I mentioned, these decisions are binding for the individual boards. Cases are referred to the grand board where they're either legally complex or where there's a diverging case law, so it has a sort of harmonization role, or where a case is particularly important for other reasons. And you can find more information on the website that's indicated here. Next slide, please. So what would be an example of a case? Well, you can see this Iceland case. This was actually a cancellation involving cancellation of 2 trademarks, both for the country name Iceland, which was registered by a British supermarket, and the Republic of Iceland objected to that registration and tried to remove both the figurative trademark and the word mark from the register. And we actually had an oral hearing in this case, which I would say that is quite it was the first oral hearing the Grand Board had ever had. And just for the record, most of our proceedings are by written procedure. And the Republic of Iceland was successful in removing both these trademarks, although both these decisions are now, they've been appealed by the supermarket to the General Court, so we have to wait and see whether the General Court agrees with us. Next slide, please. So, as I said, most of our decisions stop at the level of the Boards of Appeal. Parties do not go further. They do not go to the court. You can see that in nearly 90% of cases, on average, 89% to be more precise, the Board of Appeal ends up taking the final decision. Next slide, please. In terms of what's the caseload before the General Court, so last year you'll see that some 302 cases were decided by the General Court, and there were oral hearings in 101 cases. Now, there were 52 cases that were further appealed to the Court of Justice. However, in nearly all those cases, the Court of Justice declined to accept the appeal. They said that the appeal was inadmissible. So it's very difficult to get to the 4th level. Here you have some statistics that say, indeed, since 2019, which was when the rules became much tighter for appeal to the Court of Justice, over 200 cases have tried to get to the Court of Justice, and only 7 have been successful in all that time. One of the reasons is that to have a successful appeal, the Court of Justice requires that the issue be a matter of the unity and coherence of European Union law, so not just trademark or design law, but the law in general. And that's an extremely difficult burden to discharge. Next slide, please. The good news for us is that when our cases are further appealed to the General Court, in nearly 87% of cases, the court confirms our decisions. They uphold our decision. Next slide, please. Yeah. And then just a quick word to say that last year in November, we launched our mediation center. However, at the level of the Boards of Appeal, we've been offering mediation since 2011, and the parties have the possibility of of choosing to try and mediate their case, their appeal. If the mediation is unable to reach a settlement, then the ordinary appeal proceedings will recommence, and therefore there's really very little to lose by having a go at mediation, apart from a bit of time. And the mediation is included in the appeal fee. Therefore, it comes at no extra cost. Last slide, please. And then just to say that the forms of alternative dispute resolution services that we offer are listed here. Since my colleagues, I want to leave time for them, I won't go into that. I saw also that there were quite a few questions that came as I was speaking. Unfortunately, I couldn't read them all and go on. Perhaps I can deal with them at a later stage if we have time. Thank you very much.
Thank you, sir. It was really a very interesting presentation. I also request Ms. Nina Korjus, the chairperson of the 4th Boards of Appeal, and Ms. Janka Budodikova, the project manager of Boards of Appeal, to kindly present their insights. Thank you.
Can you hear me well?
Yes, we can.
Yes, okay, good. Thank you. So, good afternoon, also from my part. Happy to be here to discuss with you. So first, I will give you a general overview of how the boards work, and secondly, I will describe the running of appeal proceedings and highlight certain specific procedural points. Next slide, please. So, which actions can be appealed? Well, actually, our president already mentioned these decisions, but maybe just briefly. Well, firstly, they need to be final decisions, and so decisions of the examiners concerning, for instance, the filing date or formalities, or if the trademark applied for refused for absolute grounds of refusal. So this can be appealed. Then decisions of opposition divisions, of cancellation divisions, and also of the registry. What is important to note is that a decision which does not terminate proceedings as regards one of the parties can only be appealed with the final decisions. And what are then these decisions? For instance, decisions rejecting an opposition due to lack of substantiation of one of several earlier marks. So this decision is subject to appeal. However, it can be appealed together with the final decision. And here the idea is to enable the office to completely process a whole case instead of having to wait for example, interim decisions to become final after following possible appeals. And this obviously speeds up proceedings. And quite often, most often, only one decision is needed in any case. Next slide, please. This slide explains the workflow for appeal proceedings for ex parte cases and inter partes cases. First, as regards ex parte cases, the applicants have 2 months from notification of the first instance decision, which is indicated in the slide as contested decision, to submit the notice of appeal. They have 4 months from the notification of the contested decision to submit the statement of grounds. And if the statement of grounds are not filed, then the appeal will be inadmissible. And in ex parte cases, there is also a possibility for revision. So during 1 month after the statement of grounds, the first instance can still review its decision and see whether actually they should revise it or not. And if they grant the revision, then there will be no decision from the boards. But if they don't grant the revision, then of course the boards will then take a decision. As for inter partes cases, the beginning is exactly the same, so 2 months for notice of appeal, And yes, I forgot to mention also the appeal fee needs to be paid in 2 months, and then 4 months for statement of grounds. After that, the other party, the defendant, has 2 months to submit a response. And in this context, I could mention also that the defendant may, in its response, but actually in a separate document, this needs to be done, seek a decision annulling or altering the contested decision on a point not raised in the appeal. So this is the so-called cross appeal. So the defendant in the parties' cases can make a cross appeal at the stage of response. Of course, I mean, the defendant could have already done its own appeal at the same time, more or less, than the appellant, but then we have multiple appeals. So that's then another issue. After the response, the appellant can request for a second round, but this is a bit exceptional and it needs to be justified. So if in the response there are just the same arguments that at the first instance, there is no need to grant any second round. But then if, for instance, the defendant has submitted some new evidence which could be relevant for the outcome of the case, then we usually grant the second round so that the appellant can file its reply concerning this new evidence. And then after that, we also will give 1 month for the defendant to file its rejoinder. So let's move to the next slide. And this is about the e-appeal. Most of our cases, well, I think the percentage is something like 99.90 something percent. So most of appeals are filed via e-appeal, electronic appeal. And this really helps to avoid deficiencies, and this speeds up the proceedings. And here what could be mentioned, yes, one should be careful with the names so that the names are correct. And then what I could also highlight is on the right side, under in the middle of the right side, you see extent of appeal, and there you see decision contested in its entirety or in part. So here in these boxes, you should indicate whether the decision is contested as a whole and or in part. And this, I want to highlight, this concerns only the goods and services. So not the grounds or anything else. This really concerns the goods and services. And for instance, if the examiner has refused to the sign only partially, then in principle the appellant should appeal only in part, because it is adversely affected only by this part by which its trademark was refused. Then, of course, I mean, if it's indicated that it's appealed in its entirety, we make a decision on the admissibility of these goods and services. Also here, language of the appeal needs to be indicated. And then what I could also mention as regards representatives, for employee representatives, we need a general authorization for all the employees. And also confidentiality requests should be made here by giving the reasons why something should be kept confidential. Next slide, please. So what can the board then decide? What are our competencies? We have the option to either exercise any power within the competence of the department which was responsible for the decision appealed, or we can remit the case to that department for further prosecution, which is then bound by the decision's ratio decidendi insofar as the facts are the same. So we can either do the full review and, for instance, filling gaps of decisions, or we can remit. And remittals are optional. and we have wide discretion on that. So if we remit, this emphasizes the nature of appeal proceedings as a true second review of facts and arguments resulting in a contested decision. But then if we don't remit, then this means that the case is dealt with expediently. But for instance, if the proof of use was not examined by the first instance, because the opposition division, for instance, took a shortcut and considered that even if a proof of use would have been shown, even if goods and services were identical, still the trademarks compared are so different that in any case there would not be any likelihood of confusion. And then if we as a board consider that actually the first instance made an error when it assessed the similarity of the signs, and according to us, there could be actually likelihood of confusion. But since the opposition division did not examine the proof of use and did not compare the goods and services, normally in these cases, we remit the case back to the first instance so that the parties really can have this two instance examining the facts. So, but then in some cases we might take the decision, but this is then a different scenario. But normally we remit the case back if the first instance has omitted to examine some of the relevant factors. So, what decisions can we take? We are still in the previous slide. Can I have that? Thanks. In practice, we can take a range of decisions already before we take the decision on the subject matter, such as decisions on inadmissibility, on requests for restrictions of the list of goods and services, on confidentiality requests, etc. But then we of course have the main decision on the subject matter, which closes the appeal proceedings. And also, we normally in the same decision, we take the decision on costs in inter partes decisions. And then if something went wrong in our decision, we can either revoke our decision in 1 year after the decision has been taken, or we can correct our decision. And in which cases we can revoke? Well, if we have made an obvious error, but it really needs to be an obvious error. And then what can we correct? We can correct the linguistic errors or errors of transcription or manifest oversights. But we need to be careful not really to be limited to those. We cannot just do a new decision and call it a corrigendum. So it's limited really to these kind of technical errors. Next slide, please. Yes, thank you. So this is about our scope of review and subject matter, and this is related to goods and services. As I mentioned earlier, the appellant would need to indicate already in the notice of appeal to what extent the contested decision is appealed. So to what extent the goods and services are concerned. And if, as I think I already mentioned, so if there was only a partial refusal for goods and services and the contested decision is appealed in its entirety, well, obviously the appellant is not adversely affected regarding those goods for which it already gets accepted. So and then in this context, I could also mention the possibility to reopen for absolute grounds of refusal. If in an inter partes case, in an opposition proceedings, if we consider that the contested sign in question actually should have been refused already on the basis of absolute grounds of refusal. We can suspend the opposition proceedings and make an internal referral decision where we propose to the first instance to reopen the examination of absolute grounds. And then in ex parte cases, if we consider that actually the marks should have been refused also to some other goods and services than those for which the examiner refused it, then we can recommend to examiner to reopen the absolute grounds. Next slide, please. What about then facts and arguments? What can we review at the appeal stage? In ex parte cases, we can raise new grounds, facts and arguments, provided that the right to be heard of the applicant is respected. This means that, for instance, if a trademark application has been refused on the ground of lack of distinctive character, but we think that actually it should have been refused on another ground, for instance, technical function. So we can do that ourselves without remitting the case back to the first instance, which we can also do. But if we do it ourselves, we need to give the applicant the possibility to comment on that. So in that case, we will normally send a communication to the applicant by explaining why we think that actually this trademark application is covered by this ground. In inter partes cases, we are in principle restricted to the grounds invoked in the statement of grounds or in cross appeal. There are, however, some exceptions to that. For instance, matters of law concerning essential procedural requirements. For instance, if we see that there is an inadmissibility issue, so of course we should raise that ex officio. Also, we can examine matters of law which are necessary to resolve in order to ensure a correct application of the EUTM regulation. And what are these? For instance, in opposition proceedings, if the parties don't say anything about the comparison of goods and services, and they concentrate only on the comparison of the signs, but we see that there actually is a clear error in comparison of the goods and services, then we should raise that issue and assess that ex officio, because otherwise the regulation would not be correctly applied. If we found that actually the goods should have been considered dissimilar instead of similar, obviously then there cannot be any likelihood of confusion. Also, matters of public interest and well-known facts can be taken into account. I could also mention that certain claims must be raised both before the first instance and again in the statement of grounds or in cross appeal. And these are, in ex parte cases, acquired distinctiveness, and in inter parte cases, recognition of the earlier mark and proof of use. So if the issue of proof of use is not raised again at the appeal level, so we need to take it. We need to consider that the findings of the first instance are kind of binding on us. We are not assessing them, so we don't say that we endorse them or anything. We just say that goods and services are deemed to be used for these and these goods. So, and my final slide, as our president already mentioned, most of our cases are dealt with written proceedings. Most files are sufficiently complete in order to deal with them in written. And Oral proceedings can be held at the recent request of a party or on the board's own motion. And here the test is on whether to hold an oral hearing is expedient. And we have a wide discretion. And if we think that oral hearings could be useful to explore some evidential issues, then we can have them. And as our president already mentioned, we had an oral hearing in the Grand Court case Iceland in September 2022. And this was a hybrid oral hearing because there were almost 1,000 connections in total. So it was very, public was interested in it. And then before that already, during COVID times, we had our first online oral hearing. So that's it for my part. Thank you.
Thank you, ma'am. I request Ms. Janka to kindly proceed ahead with the other activities of board. Thank you. Ms. Janka, we aren't able to hear you.
If there's a problem with Janka's connection, I'm happy to take over if she can't access.
I see Ms. Janka on unmute, but still I can't hear her.
Then if I would suggest that in the interest of time, because I know it's getting late for you in India, so we'll try and be quick here. Would just give Janka one more chance. If not, then I'll jump in. Janka, are you able to connect? It seems not, so let's move. Yes, just to say that apart from decision taking, we also have working groups that try and make an analysis of trends of case law, and this helps the people drafting decisions to identify the relevant case law. It's obviously not binding on the members of the boards of appeal because we're independent in our decision making. Nevertheless, it's a very useful tool, and I think there's a link here in case anybody's interested in knowing more about these reports. Next slide, please. Yeah, and we've so far published 18 reports, and various translations have been provided. Next slide, please. We also have various networks with the national offices, so the offices of the individual 27 member states of the European Union. That we network with their appeal bodies. We discuss our consistency reports and various other decisions and judgments with them. We also discuss with judges sitting in the national courts that decide on infringement matters in trademarks and designs, remembering that at the boards of appeal, we only decide on register matters, whether a trademark or a design continues to be on the register or enters the register, not about whether it infringes on the market another trademark, which is dealt with by national courts at national levels. And we have meetings within the boards of appeal to try and ensure that our decisions are as coherent and consistent with one another as possible, bearing in mind that, of course, we're dealing with facts and law, and facts are not always absolutely identical, but what we try and avoid is making any inconsistency in our decision making. Next slide, please. We not only cooperate with judges and the national offices of the member states of the European Union, but we also cooperate with the largest so-called TM5, that's the Japan appeals division, the Korean Trial and Appeals Board, and the US Trial and Appeals Board. And we also cooperate with the Singaporean office and exchange ideas on various matters, have by usually online by sessions such as the one we're in at the moment. We have a user focus group by which the representatives that act before us, and just to draw a parallel with what happens in India, we have a similar situation to you. We have patent and trademark agents as well as legal practitioners, so advocates. And we meet with representatives of those groups twice a year. We cooperate with also the European Patent Office and with the WIPO on a regular basis, and we participate in giving training in the context of the Judicial Institute of the WIPO. Next slide, please. Here you have some useful links in case you're interested in learning anything more about our case law, decisions of the Graham Board, our case law research reports, an overview of our decisions, and an overview of the leading cases on trademarks coming from our General Court and Court of Justice, so our higher courts. Next slide, please. And that's it from us. Thank you very much. I'm sorry that was a very long presentation from all of us, and really we're very grateful for your patience. And if there's any time, we're happy to take questions. Thank you.
Thank you, Mr. Gaudi, Ms. Meena and Janta, for your lovely presentation. It was indeed delightful.
Himadri, I would like to just check with the participants. Quickly give your feedback. Should we take one or two quick questions on this? You can raise the hands, or you can give the symbolic acceptance like this, so that we can keep. Himadri, just take a couple of questions. We are already running short of time, but it would be good to have quick questions. Yeah. I leave it to you to prioritize the questions.
Thank you, sir. I have a question for Mr. Humphreys. It says that what's the role of the mediation in the process of appeal in European Union IPO?
Yeah. Yes, thank you. I mean, very basically, it's a voluntary process, so nobody is forced to mediate. As I mentioned, the mediation fee is included in the appeal fee. Since the launch of the mediation center at the end of last year, mediation will become a possibility at all stages of EUIPO procedures. So both before examiners and before the boards of appeal, but only in inter partes adversarial proceedings, right? Yes, the advantage here, I'd say, is that you can, if the dispute is between the same parties, it can involve not only trademarks or designs, but any other IP right that the parties wish to negotiate about. And that IP right can be located anywhere in the world, but there has to be at least one European Union trademark or design that's at issue. I hope that answers the question.
Thank you, sir.
Himadri, last question.
Okay, last question to you, sir. What should, considering we have Mr. Humphreys and the team of EUIPO among us, we have a question which asks you what should be the way forward for India to increase its application in EUIPO? Sir, this question is to you.
To whom is the question addressed?
It is addressed to Mr. Professor Dr. Unnati Pandit, but
Okay.
I think he's into some other considerations. I would like to change the last question to Mr. Humphreys again. So what could be the possible reason for China having the highest number of trademark and design applications in European Union?
Okay, thank you for that question. The answer is I think fairly simple. The Chinese government has given large subsidies to Chinese companies to make filings abroad, I believe both in the United States and the European Union.
Thank you.
Before we close this session, I would request all the participants to please turn on your camera so that I can capture the photo and then we'll also share it with the EU team for posting this on the social media also. So quickly, if you please turn on your camera. Everyone has the access to turn on their camera. If anyone is facing any problem, do let me know so that this moment can be shared with the stakeholders in India and Europe also, and this will help all of us to make sure that we are in sync with the developing scenario into the European Union and the Indian IP regime also. So wonderful. Thank you very much. I am really feeling very happy that this is one of the good beginning in sharing the knowledge between the European Union IP office and the Indian IP office. And there are several such avenues on which we have so many good knowledge sharing, which can benefit to both the sides and their stakeholders, especially in amplifying their IP protection, especially in trademark. And we look forward to have the series of such virtual roundtables, participation involving the stakeholders from both the side, and certainly amplifying the impact of a IP regime both the side. So I thank Mr. Goron Humphrey and the team from the European Union IP office for such a wonderful interaction, and equally I congratulate the Sanjay Bhattacharya and Vikas Punia for their wonderful submission on the Indian side also. I am feeling very sorry to the participants. We could not able to take much question as we are already running behind the time. But if you have any questions, queries, feel free to write to the IP office. We will compile all the questions, and if at all any questions are there related to the European Union system on the appeals, we will reach out to Mr. Goron Humphrey and the team for their inputs on this. So I thank each and every participants for joining for such a wonderful IP Manthan. This is one such beginning with the EUIPO. We will continue to have this calendarized interaction also, if possible, on both the side, and we will actively have this kind of a discussion. And I am sure all the Indian stakeholders would have much insightful understanding about the EUIPO's trademark regime. Appeal is an important element in protection of the rights, and similar topics we will work out with the EUIPO team and will plan, and we will ensure that we have the adequate time for the question answer also, like we are doing for other IP Manthan also. Once again, thank you very much. Namaste.
Thank you very much. Delighted to help in any way we can. Thank you. Goodbye. Wish you all a pleasant
Goodbye.
evening. Goodbye.